So, what's your best tip when someone's been drinking a little or a lot, and they've been pulled over, and the police are walking up to them? What should they do? What shouldn't they do?
Well, I think that one of the things that we see a lot of is people they want to be honest with the police, and that tends to be a good thing. But they want to kind of go with the, well, I only had a couple of beers, officer. And to be honest with you, police officers hear that so much, especially in the context of a DUI stop, that you know trying to be honest that you had something to drink but you only had two beers, you're not going to be believed. So if the police officer asks you if you've been drinking and driving, the first thing I would recommend is remaining silent on that issue. You don't have an obligation to respond to that, unless it's true that you only had one beer. But even that, pretty rare circumstances that's the case.
Yeah.
The second thing is that in Colorado, when you're stopped and the police officer believes that you've been drinking and driving, one of the first things that they're going to generally do is ask you to exit the vehicle and do a set of roadside maneuvers. And doing those roadside maneuvers is going to, basically determine whether or not the officer has probable cause to arrest you, or if the officer believes that you're not under the influence is going to let you go. The most important thing to know, though, about those roadside maneuvers is that those are 100% voluntary. There's no penalty under Colorado law or any other part of the DMV or anything else like that requires that you participate in those roadside maneuvers.
Okay.
So if you're obviously pulled over, you've been drinking and you don't feel like you're going to pass those, it might be a situation where if you're thinking properly, which oftentimes when you've been drinking you're not, maybe not performing those roadside maneuvers because they are 100% voluntary. The other thing is that once the police officer determines that there's probable cause to arrest you, they're also going to have enough probable cause to ask you to submit to a chemical test under the express consent law in the state of Colorado. And so if you're driving on any road, highway, anything like that in Colorado, you've already consented to take a chemical test if the officer asks you to do that. And in the context of an alcohol-related DUI, you have a choice between a breath test and a blood test. Technically, the decision to take any type of chemical test is voluntary. There are penalties, though, associated with choosing not to take a test. That could be a full 1-year loss of your driver's license with no chance for any type of probationary or restricted license. And as well as if you were to go to trial, the prosecution could introduce evidence that you refused to take any tests as proof of guilt, i.e. that you chose not to take the test because you knew you'd fail it. So generally it's a better idea, to take the test. What test you want to take is up for debate. The blood test is more accurate. There's also a little bit more moving parts that are associated with that because generally you have to go to an EMT or firehouse or maybe a hospital to get that done. But the other advantage of a blood test is you can usually retest it. They usually do 2 samples, so you can verify the results independently. So it's kind of hard to say what's better, a blood test or breath test, because it's going to depend upon circumstance.
Right.
But in some cases, the blood test is, like I said, more accurate, but you also have the chance to retest it.
When you talked about refusing the field sobriety test, what literally would you say to the police officer, or could you say to refuse it? Do you just say no? Or what would you say literally?
Well, like I said, it depends on how, that's always a tough question to answer in the context of a DUI stop, because if the person is under the influence, they're probably not going to be thinking it 100% properly.
Right.
So, you're not going to have a normal conversation with the police officer. But if you have your head on straight and you're thinking pretty normally, the way that I would present it to the police officers by saying, officer, my understanding is that what you're asking me to do is 100% voluntary. Is that correct? Yes, sir, it's correct. Yes, ma'am, it's correct. And then saying, well, then because it's not mandatory and because it's 100% voluntary, I'm going to choose not to participate in that. Also, there's other good reasons not to participate in that, because a lot of those tests can yield what I call false positives. For example, if you've ever had a knee or ankle surgery, or if it's cold outside, or you don't have good balance. A lot of times, I think that the studies over the years have shown that people who are completely sober can fail those tests. So if you have a physical limitation, that's also a good reason not to participate in it. If you've ever had a head injury or if you were involved in an accident as part of the DUI investigation, maybe you don't want to do the horizontal gaze nystagmus test because you don't feel that it's going to produce accurate or fair results. So there could be lots of explanations that you give to the police officer about why you don't want to do it. But the most important thing is to always be polite and then to remember that, they are in fact voluntary.
Okay.
That's the main thing.
Okay. Next question is, so what percentage success have you had in either, getting a DUI knocked down to a wet reckless or reducing fines or, getting rid of jail time, things like that?
Absolutely. Well, I can say that in every case we've been successful to some extent getting fines reduced or getting alternative jail sentences imposed if there's mandatory jail time because it's a multiple offense or because the BAC is greater than .2. I have had a number of cases that have resulted in what they call a wet reckless driving offense. Those are pretty rare, though. In Colorado, there's a statute that basically prevents the district attorney's office from pleading down drinking and driving offense to a non-drinking and driving offense unless they can show to the court, and they have to usually make an offer of proof to the judge of good cause. Basically, they think that they would lose at a motions hearing, or possibly the BAC was really, really, really low, like very close to the .05 limit. But I've definitely had some of those circumstances happen and arise, based upon whatever it may be, an improper stop by the police officer or whatnot. So yeah, we're able to get something for everybody. They never, get the full book thrown at them. I've never had that situation occur.
Okay.
And obviously at trial, every time we've gone to trial, the goal of trial is to win. We've either completely won at trial, or the major charge, the DUI charge, was dismissed, and maybe there was a conviction on the lesser included offense, like a DWAI or some other traffic offense.
Okay, and that leads right into the next question. So, is it wise to take a DUI case to trial or to settle instead, if it's a non-aggravated DUI, if there's nothing untoward that's going on?
Well, it depends on circumstance, and each individual case is different. And I think that's why it's important that if you're facing a DUI charge, that you contact an attorney and you talk to that attorney about your particular circumstance. It's very hard to generalize because each case is going to be a unique set of circumstances. And so, the very first thing that you're going to look at is, how were you contacted with the police? Was it an investigatory stop, or was it a consensual encounter with the police? Were you driving the vehicle? Were you not driving the vehicle? What does it mean to be driving a vehicle? There's a kind of an odd legal definition of what it means to be driving, at least in the state of Colorado. It's really more about, did you have physical control over the vehicle than were you actually in motion with the car on and moving? What exactly happened with the roadside maneuvers? Was there probable cause to arrest you? What happened with the chemical test? Was it a blood test? Was it a breath test? Were all the particular rules followed that go into those different things? And based upon what we may or may not find in the investigation of your case, it may be that there is a significant problem with the prosecution's case. And if that's the case, that's when you take it to trial. Or the other circumstance in which you take it to trial is which, the person is facing jail time and they can't have that, situation for their job, for their family, whatever it may be. There's all kinds of circumstances and reasons why you may take it to trial. Even for a person that's a first offense and it's not an aggravated situation, the burden of proof in any criminal case is always on the prosecution. And, sitting down and talking with myself, we're going to sit down and look to determine whether or not the police have, basically done what they're supposed to do, and whether or not they have a case that, can be won at trial, or whether or not it's a situation where mistakes were made or questions are unanswered, and maybe we want to push the situation or push the envelope. Like I said, not all the cases necessarily go to trial. A lot of times they get resolved at a motions hearing situation.
Okay.